Hello, you're watching Adelshaw Goddard's Employment Channel. The General Data Protection Regulation, or GDPR for short, is an EU regulation due to come into force on the 25th of May 2018. The GDPR is going to impose greater data protection obligations on European organisations, including more reporting requirements and higher penalties for breaches. The UK has confirmed that it will be implementing the GDPR because it'll still be a member of the EU on this date. In August this year then, the government published the first draft of a new data protection bill, which will bring the GDPR into UK law and establish the UK's position on data law post-Brexit. In today's programme then, we summarise the key changes for HR under the GDPR and suggest some specific action points to consider before it comes into force next year. We're delighted to welcome Helena Brown, a partner in our data protection team, to tell us more about the forthcoming changes and the steps that HR can be taking now to prepare for next year. Thanks, Helena.
For HR and employment functions, particular issues are thrown up when it comes to data protection compliance. More often than not, you're dealing with sensitive categories of information, for example, medical records. In addition, you're often dealing with situations where individuals are aggrieved or complaining, and often you're the department on the receiving end of subject access requests. We do expect the impact of GDPR to mean that an increased number of subject access requests will be made. The removal of fees for making subject access requests, plus the shorter response time of a month, will make a difference. So it's important that you're prepared for subject access responses. This means having a good, strong subject access policy in place and training in place so that all staff in the team know how to identify subject access requests and how to handle them. Under GDPR, the exemptions to subject access are largely maintained. However, there are some differences, and in particular, the exemptions around disproportionate effort in responding to requests are no longer available under GDPR. This means that you need to be really rigorous with your filing to prepare for subject access requests so that you're not, at the time of receiving request, looking at a huge amount of information that might not be relevant or might be problematic from a disclosure point of view. That policy should follow through into your practices for file keeping and recording information in the first place. Good practices up front can prevent problems further down the line. So just now, in preparation for GDPR, it might be useful to review your HR files and remove any information that's no longer necessary and may cause difficulty in a subject access context. Now is also the time to put in place subject access policies and training to ensure that when requests do come in, you're able to meet them appropriately. HR teams may also from time to time become involved in monitoring requests, particularly where there may be a performance issue. The rules in GDPR on transparency and fair processing notices are enhanced, and that means that individuals have enhanced rights to more information about how their personal data is processed and what it might be used for. In particular, if monitoring is going to be carried out, policies and procedures on monitoring need to be adequately notified, or you won't be able to legitimately carry out monitoring or indeed use any of the information you've obtained from monitoring for disciplinary or evidentiary purposes. This means that you should look closely at staff handbooks and policies and make sure that monitoring is highlighted. In particular, the use of any CCTV. GDPR does not prevent use of information arising from monitoring, but it does restrict more closely what is permitted to be used in that context. Another significant change in GDPR for HR teams is the change to the laws on consent. Many of the activities we carry out in HR teams involve the processing of sensitive personal data, now called special categories of personal data under GDPR. Historically, we've used consent as a justification for processing some sensitive data, for example, criminal records checking. GDPR is clear that consent is not likely to be valid in an employment context because of the imbalance in rights between employer and employee. Arguably, that's always been the case under the Data Protection Act anyway, but it is explicit now in GDPR. This means that any activities you have been carrying out on the basis of consent will need to be re-examined in the context of GDPR. It is useful to note that the current UK Data Protection Bill, which implements GDPR into the UK, maintains many of the justifications for using sensitive personal data in an HR context that existed anyway under the Data Protection Act. So it is a case of simply looking at these and checking that your procedures fall within that. For example, is the processing necessary to observe your rights and obligations as an employer and under employment law? If so, that's going to still be justified under GDPR and the new Data Protection Bill. Any procedures you use at the moment for investigating criminal activity, if justified under the current Data Protection Act, are also likely to be justified under the new Data Protection Bill. I should caveat that, of course, because as at the date of recording this webinar, our Data Protection Bill is still in draft format and is subject to change. However, it embodies concepts that we've had in data protection law, and in particular in relation to the use of sensitive personal data in an employment context, that have existed for some time. What does this mean practically? Practically, it means that if you do refer to consent in your employment contracts, and if you attempt to catch all consent, that's not going to be recognised as valid under GDPR. And it's probably not necessary either when you look at the other justifications that exist for using sensitive personal data or special categories of personal data in an employment context. In practice, what this means for employment teams is that going forward, contracts can be revised to remove references to consent where you no longer need them. In addition, your fair processing statements that you give to staff, whether that's by way of a data protection policy or a statement in your staff handbook, can be updated to refer to the new legislation and to refer to the new justifications for using particular categories of personal data. I should emphasise that in an employment context, again, whilst it's not necessary to obtain consent, and whilst there are justifications for using sensitive personal data, it is important to be transparent with individuals about how their personal data might be used, and in particular if that includes special categories and sensitive data. There are some limited exceptions to giving full fair processing information if, for example, it would prejudice criminal investigations to do so. But generally speaking, more transparency is required under GDPR. We're finding that most HR teams are requiring to update their fair processing statements and policies as well as their employment contracts. So in summary, the main impact of GDPR on employment teams will be in relation to employment contracts, fair processing statements, updating policies, and ensuring you're prepared for the new subject access rights. Sitting behind all of that are the enhanced penalties for failure to comply with GDPR, and in particular where that involves sensitive personal data. The general principles that apply to GDPR, such as security and not keeping information for longer than necessary, are particularly important for HR teams because of the volumes of sensitive personal data that you process, and therefore it's even more important that you choose systems and procedures and put training in place to make sure that your sensitive HR information is protected. Thank you.
Thanks, Helena. There's obviously plenty to be thinking about over the next few months then. Finally, it's also worth mentioning that personal data breaches will need to be reported within just 72 hours to the UK's Information Commissioner. And with the maximum fine standing at 4% of global annual turnover or 20 million euros, whichever is the greater, the potential penalties under the GDPR are pretty head-turning. However, the Information Commissioner has said that these top-tier fines will only be for the most serious of breaches and won't be handed out for smaller infractions. You'll find our guide to the GDPR in the pack of supporting materials to this programme. We expect to be adding to this during the course of next year, so please do just get in touch with us if there's anything we can do to help you prepare for the changes in May. That's all for today then from Addleshaw Goddard's Employment Channel. Thank you for watching and see you next time.